Good evening and welcome to Coast to Coast Legal Aid's virtual clinic series. Tonight we're going to be meeting with attorneys from our Family Law and Domestic Violence Unit and pro bono attorneys to discuss family law and domestic violence. Tonight, our guest host is from Children's Services Council, Program Manager Tabitha Bush. Thank you, Tabitha, for being here with us tonight as our guest host.
You're welcome.
We also have Mindy Jones, who's president of Broward Domestic Violence Coalition and a supervising attorney at Coast to Coast Legal Aid. So welcome, Mindy. Thank you for being here. We have Lisa Goldberg, who is our director of the Family and Domestic Violence Law Unit at Coast to Coast Legal Aid. And we have Jason Haber here, who is our pro bono attorney and is generously giving us his time this evening to be a part of our clinic series. And Jason is with Haber Blank LLP. So we want to welcome Jason tonight for being a part of our clinic. For anyone watching, please keep in mind, you can post questions in our comment box on Facebook Live. However, we will not be answering any questions that would violate attorney-client privilege. So you can't ask specific legal questions. We'll monitor those and we can present the ones to the panel. But thank you everyone for joining us tonight. And I'm going to turn it over to Tabitha now as our guest host for the evening. Thank you.
Good afternoon, everyone, and thank you for joining us for this virtual clinic on this evening. So I just wanted to give you a little background information of the Children's Services Council, that we fund close to 100 programs that serve children and families. We also advocate for policies that protect the interests of future generations and provide leadership that brings the child serving communities together. So we're going to cover a lot of topics tonight, but I would like to start out with having a discussion about domestic violence and intimate partner violence. So Mindy, this first question is for you. Can you first tell us what the Broward Domestic Violence Council is?
Of course, and thank you again for having me. The Broward Domestic Violence Council is made up of various agencies and organizations throughout Broward County, which come together in a coordinated effort to better serve victims of domestic violence in our county. Some of the organizations obviously include Children's Services Council and Coast to Coast Legal Aid, but also the State Attorney's Office, law enforcement-based victim advocates, Broward Certified Domestic Violence Shelter, which is Women in Distress, Kids in Distress, the Department of Children and Families, Court Administration, and many others. The council works together to find victims a safe place to stay, offer relocation assistance, obtain financial support, victim compensation, secure injunctions for protection, keep victims informed of their rights and what's going on with their cases, and access any resources that may be available to them.
Okay, thank you. And can you also give us an overview of what an injunction is in the family law context?
Sure. An injunction for protection, which is also known as a restraining order or a protective order, it's called an injunction for protection here in Florida. A victim can go and file a petition for an injunction asking the court to require the opposing party in a domestic violence situation, that may be a spouse or a significant other. They could ask the court to require that person to not have any contact with them and to stay away from where they live, work, or go to school or any other place that they may go often. Depending on the type of injunction, there may be other terms that they can include as well.
Okay. And when you talk about injunctions and restraining orders, can you kind of tell us what are the main differences between the 5 types of injunctions?
Sure. So there are 5 types in Florida. So there's domestic violence, dating violence, stalking violence, sexual violence, and repeat violence. Mainly it's the difference is the relationship of the parties and also the type of violence. Okay. So we know that, I'll talk about domestic violence first. We know that domestic violence is about power and control, right? So for an injunction, not all controlling behaviors may qualify for an injunction. So things like emotional abuse or psychological abuse, financial abuse, We in the community, we recognize that those are forms of power and control, and they are forms of domestic violence, but the law may not consider those enough to qualify for an injunction. So for a domestic violence injunction, you either have to be spouses, current or former, related by blood or marriage, residing together as if a family unit, and that does include same-sex relationships, or unmarried couples who have a child in common, regardless of if they ever lived together. And then the law defines domestic violence as an assault, an aggravated assault, a battery, an aggravated battery, sexual assault, sexual battery, stalking, aggravated stalking, kidnapping, false imprisonment, or any other crime that results in an injury or death of a family or household member. The other types go into, I'll talk about dating. Dating violence is when the parties were engaged in they call it a continuous and significant relationship of a romantic or intimate nature. And the relationship had to have existed within the last 6 months. And again, the violence would be those same enumerated crimes. There's also sexual violence, which is an incident of sexual battery, lewd, or lascivious act. There's repeat violence, which you need 2 incidents of stalking or violence. One of the incidents had to have occurred within the past 6 months. And this we see mainly with people like neighbors or coworkers. And then there's also stalking, and that's when a person willfully, maliciously, and repeatedly follows, harasses, or cyber stalks another person. So they use the misdemeanor definition for that.
Thank you so much for explaining the 5 types of injunctions. You mentioned before who can file the injunction or the restraining order. Can you file on behalf of another person?
So you can actually file on behalf of another person if you are the parent or legal guardian of someone else, let's say your child, and the child was a victim, then you can file a petition on behalf of the child.
Okay, awesome. Has the injunction process changed due to the current climate now with COVID-19?
So just a little bit. You still can file for an injunction for protection or restraining order. Injunctions are considered essential by the courts, and our chief judge, Judge Tudor, and his administrative orders has always provided access to the courts for the filing of petitions for injunction.
Okay. And where, if someone wanted to file an injunction, where can they go to file the petition for an injunction for protection?
So throughout COVID, victims could always go to the 2nd floor of the Broward Central Courthouse, which is located in downtown Fort Lauderdale, 201 Southeast 6th Street. On the 2nd floor, room 02140, to file for a petition. During COVID and right now, still, while social distancing is in place, you still have to wear a mask to enter. And you would tell the security guard or a deputy at the front entrance that you're there to file for a petition. Recently, the West Satellite Courthouse also opened up for the filing of petitions, and that's in Plantation, and that's located at 100 North Pine Island Road in Plantation. So the main courthouse, you can go down Monday to Friday between 8:30 a.m. and 5 p.m. When you go to West Satellite, the hours are a little bit different, 8 a.m. to 2 p.m. And then for people who need an injunction after hours, they can call Women in Distress's crisis line. That number is 954-761-1133. And they'll determine whether you're eligible to file for a petition for injunction outside of the business hours. You can always check the websites for the Clerk of Court, which is browardclerk.org, or the 17th Judicial Circuit, and that's 17th.flcourts.org. And they are very good about updating with any new information relating to COVID changes. Mm-hmm. And there's also an emergency number for people who maybe don't have internet access, although I guess if you're watching this, you probably do. But that phone number is 954-831-7777.
Thanks, Mindy. I also have another question for you. What if the victim doesn't know their respondent's contact information?
So if they don't know the respondent's contact information, let's say the person took off and they don't know where they went, you can still file a petition. So when you file a petition for an injunction, you fill out something called a respondent description information page. So they'll ask where the respondent lives, but they also ask where the respondent works, where the respondent's close relatives live, and where the respondent hangs out. And they'll also get the respondent's phone number. The clerk of court provides an emergency service packet, which is something that you're actually going to get in your hands. You can use that to have law enforcement serve the respondent if you happen to encounter them out in public. But, you know, the clerk sends the packet over to the Broward Sheriff's Office to serve the person. And many times the sheriff may just call the respondent if you actually have a phone number. Phone number, email address, or other contact information for the respondent, and the respondent does not get served, then right now the temporary injunctions are extended and being reset for a future date to give you time to try to get service, but the restraining order would stay in place during that time. And also, since we are talking about contact information, if your information is confidential, it's really important that you put on your petition for injunction that you want your own information to remain confidential, you know, your phone number, your address, your email address, mark it as confidential and let the clerk know.
Yeah, that's very extremely important. So Jason, I want to, include you in the conversation as well. And I was wondering if the court grants someone a temporary injunction, but the hearing date is before the court reopens, how would the judge hear an individual's case if the courthouse is closed?
Sure. So right now, all the judges in Broward County are handling, and really outside of Broward County as well, but in Broward, they're handling everything through Zoom. So there is a Zoom link. If anyone isn't sure, they can look at who their judge is and go to the Broward County court website, 17th.flcourts.org. And if you go and look up the judge, everyone will have a Zoom link there. Click on that link, and that's how you would attend the hearing. If for some reason you can't click on the link or you're unable to appear by video, there's also a phone number there as well to call in through Zoom. So it's available to everybody. It should be pretty straightforward as long as you can get on that access. If for any reason you can't, I think the most important thing is that that person reach out to the judge's assistant through that same website. You're going to find the phone number and an email address. Make sure that you're at least attempting to, so they know you're out there and trying to get through.
Okay, thank you. And what happens if the petitioner or the respondent does not attend the final hearing for an injunction through Zoom or through phone?
So obviously try to do your best to get on there. If for some reason you can't or you're unsure of what's going on, first step, like I said before, just try and reach out to the judge's assistant. The courts are being very flexible. They're dealing with this as well, and they understand technology issues. It is possible that judges may dismiss a petition. If that happens, you can go and refile. And I think that most judges are going to listen to the reasoning behind that if people had trouble getting into the link. They don't have to. Some judges may just reset it for 2 weeks later for another day. The first thing I would do is, after contacting the judge's assistant, go on and check the docket, see if they issued a new order extending the injunction to reset that hearing, or if it was dismissed. If dismissed, try and contact the judge's assistant again, or file a motion to vacate that order and have it reset, and do everything you can just to get it reset.
Thank you so much. Mindy, this question is for you. What can victims do to try to stay safe during this time?
So obviously victims should always call 911 if they feel like they're in immediate danger. The police are still responding to calls for help. So if you are in danger, you can call 911. During the time of, stay-at-home orders and these high-stress times, it's really important that victims of intimate partner violence who may be quarantined at home with their abusers or separated from their abusers to have a safety plan. They really should have a safety plan. For assistance with safety planning, victims can always contact Women in Distress. If there's a criminal case against their abuser, victims can contact their law enforcement-based victim advocate or their victim advocate from the state attorney's office. And filing a petition for an injunction and contacting Coast to Coast Legal Aid for representation should be part of that safety plan.
Okay. Is there any important information victims of domestic violence in Broward County should know?
Really, victims should just know that there is help available out there. Even during a pandemic like COVID, they can still always file for protection. You can still call for counseling and other assistance. The Children's Services Council has a great website with many resources on it. 211 Broward is a great resource. You can dial 211 in Broward County or go on their website, 211-broward.org. Family Success also. And for those of you who are watching who may not be a victim yourself, you have to understand that you have choices that somebody who's in a domestic violence situation does not have. So you can also choose to help victims by letting your friends and family know that you're a safe haven for them with no judgment. You can, in your speaking to other people, always speak in a way that doesn't blame victims. Stop asking why people stayed in these situations. Ask more why the abuser abuses, and hold batterers accountable. And everyone listening can choose to be a positive role model in this community. Challenge your friends when they say something degrading about another person and call them out on controlling behavior with their partners when you see it, and make space for everybody to have a voice in your conversations.
So I know we've talked a lot about types of injunctions and how to file the injunction, and if you can't identify the residence of the respondent. My last question is, has the Broward Domestic Violence Council identified any issues for victims during this pandemic?
So in the beginning, those first 2 weeks, the last 2 weeks of March and the month of April, we did see that filings were down about 50%. And that's a big decrease. So it did cause a lot of concern in our community about that. We have seen the numbers increasing though in May. So some of that initial decrease may have been because, on the news, everybody was just hearing everything's shut down, everything's closed, you can't go anywhere. And we worked really hard to get out the word that the court was still available for filings. During a pandemic or when we're not in a pandemic, in Broward County, shelter and affordable housing are always a need for victims. So to try to leave the situation, to have somewhere to go with their children, that's really a need that we always have. As well as safe exchange locations. So during the pandemic, you want to make sure that you're exchanging in a place that's going to be open and safe for both the parents and for the children. When victims have a safe and supportive place to go with their children, that always makes them much more likely to leave an unsafe situation. But, if not, then likely they may stay in an unsafe situation that they know rather than chance the unknown. So those are issues that we've seen during the pandemic and before the pandemic. Calling the Certified Domestic Violence Center, looking for information from the National Coalition Against Domestic Violence, or speaking with your victim advocate for advice about safety planning, whether you're staying in that situation because you're under a stay-at-home order or quarantine, or whether you can go out, I think is really important. Safety planning is definitely necessary.
Thank you, Mindy, so much for that segment with us discussing domestic violence and the intimate partner violence. I would like to move into another discussion with dissolution of marriage. And Jason, this question is for you. What's a dissolution of marriage? Is it different from divorce?
Those two are the same thing. So in Florida, the legal term is dissolution of marriage. For practical purposes, it's commonly known as divorce, but the terminology is just a synonym.
Okay. Do we need a reason why we want to get a divorce?
You don't need to have any fault or anything like that. The only reasoning is that the marriage is irretrievably broken or that it's broken beyond repair. We're a no fault state, so it's a simpler burden.
Okay. And when you mention no fault, what does no fault divorce mean? What does that mean?
Simply, there doesn't have to be a specific fault. One of the party or the other doesn't have to be at fault. If you travel to other states, you may need something like adultery or separation for a period of time. Someone having done something wrong, something to cause the divorce. You don't need that in Florida. You just have to have irretrievably broken marriage. So if one person comes forward and says, I want a divorce, ultimately it's likely to get granted once they testify that it's irretrievably broken.
Okay. So what if not my spouse? Of course, I hope not. But what if someone's spouse won't agree to give them a divorce? What happens?
That's part of it being a no-fault state. Ultimately, one party needs to testify that it is irretrievably broken. Another spouse can try and challenge that, can say it's not irretrievably broken, but they're not going to, in the end of the day, be able to hold up the divorce from happening. They can't force someone to stay in the marriage.
Okay. And Jason, can dissolution of marriage and paternity actions be filed right now during COVID restrictions?
Absolutely, yes. File them now. If you can log in and create an account to file online, otherwise they can be filed with the clerk's office.
Okay. And how do a person file for dissolution of marriage?
So to be frank, the easiest way to do it is if you're able to get online and register an account and file through the e-filing system. With the courthouse the way it is, being close to the public, that is the easiest. Otherwise, it would be to go through the clerk's office at the courthouse.
Okay. And I hear this, I've had conversations with individuals, and I know that some divorces have a long process. How long is the process how long does the process typically take to go through a divorce?
So every divorce is different. Some people will come in and do an uncontested divorce and they're able to resolve all the issues before they file. So they are able to file the entire case with an agreement and submit it to the court for approval. That would be probably the quickest way of doing it, and just going through the filing, that can be done relatively quickly. I've handled those in a matter of weeks to a month. If there's a divorce that's contested, I like to tell clients, expect somewhere between 6 months and a year. If you go to mediation and settle at mediation, it is certainly likely to happen a little bit sooner than going all the way through a trial. At this point, because hearings are being conducted by Zoom and some things are taking a little bit longer, you can expect some delays in eventually getting to a trial. But the vast majority of cases do settle. So if you're able to expedite that and go through mediation, that's probably the best bet to go through the process a little quicker.
Okay. And Jason, does each party have to go through is it required to do mediation?
So every judge I'm aware of in Broward County will order mediation absent some special circumstances. So if parties are unable to resolve a case before it goes to trial, you can expect to get an order of referral to mediation, whether that be through the court mediation or through a private mediator. There are circumstances where that may not happen, but that is more of the norm.
Okay, thank you, Jason. Lisa, I wanted to include you in the conversation as well. And how can someone apply for your services if they're served with a dissolution of marriage or paternity petition, or if they want to file for divorce or establish paternity?
Okay, right now our physical office is closed, but we have not skipped a beat. From the day after our office closed due to the coronavirus, we started accepting applications over the phone. So there are several ways that folks can apply. If it's if it's a time-sensitive case, the best way to apply is to give us a call. And I'll tell you what I mean by urgent and time sensitive. For instance, Mindy just explained to you about injunctions. When somebody goes to the courthouse and they get a temporary injunction, their follow-up hearing is going to be in 15 days, and that goes fast. So they need to call us if they want representation for a hearing for injunction for protection, commonly known as the restraining order. They should call us at 954-736-2495. All of those calls are go through our intake specialist, and the calls are returned rather quickly. We have a couple paralegals helping out to make sure that we're responding to these calls quickly. For a petition for dissolution of marriage, and let's say somebody was served with a petition for dissolution of marriage, they only have 20 days to respond. So we need them to call 954-736-2495. And we process these applications very quickly. We'll do a pre-screen while they're on the phone with us. And if we can't do it at that moment, we'll call them back. Again, this has really been a system that we formulated around this crisis, and we've really risen to the occasion. I think we're doing better than ever in processing applications when they're time sensitive.
Okay, thank you. If your office has informed someone that their case was accepted for representation to initiate a dissolution of marriage or paternity action, how long would it take for those documents to be filed by your office?
Okay, so now let me kind of address the non-time sensitive cases. The non-time sensitive case would be if they wanted to file for divorce or they wanted to file to establish paternity. Mm-hmm. In those cases, they can still call 954-736-2495, but there are a couple other ways they can apply too. We have a great website. It's coasttocoastlegalaid.org. coasttocoastlegalaid.org. And our application is actually right on the website. And in the very near future, I'm talking like in a week, in a couple weeks, it's going live so that you'll just be able to do the application right on our website. For right now, it's a fillable application. And once you fill it, you will be able to then email it back to us. And our email address is family, F-A-M-I-L-Y, @legalaid.org. And so that application can be emailed back to us, or you can fill out that application at your leisure and put it in an envelope and mail it to us. And our address is 491 North State Road 7, Plantation, Florida 33317. So I just want to make the distinction here. If it's a time-sensitive case, if you need representation for an injunction, if you got served with a divorce, or you got served with a paternity action, you need to call us. That's really the most efficient way to apply. But if you're thinking about filing for divorce or filing to establish paternity, it's just as easy for you to fill out the application and either mail it in or email it to us. But if you want to, you can call us as well.
Thank you, Lisa, so much for that information. And so, Jason, I kind of want to talk to you a little bit about parenting plans and time sharing and parent responsibility. Can you talk to us a little bit about what's a parenting plan and when does an individual need one?
Sure. So parenting plan, best way to look at it is this is going to set your life with your kids as far as a schedule and extracurriculars, everything that goes into parenting. That's why the title, through either a divorce or a paternity action. It is required in all cases. It can be done through an agreement, or if you parties can't agree, then the judge ultimately is going to rule and enter in all the details there. If you take a look at a parenting plan, you'll see it when people first look at it, it looks scary at first, because you're looking at schedules, different times of year. How are you going to do all these things? How are you going to make decisions as separate parents? That a document will give you all that. It'll give you all that information. Ultimately, the main sections, obviously your time sharing, that's your schedule, typical schedule, Monday through Sunday, who's going to have the child on what overnights. And then from that, there's also a holiday schedule that can be filled in. There may be some other special times a year, whether it be 3-day weekends where you have off of school, spring break, summer, winter break. The idea is to address all of that. So there shouldn't be a question. If there's ever a dispute, the parties can always turn back to that parenting plan and say, okay, it's the Monday of spring break, who's supposed to have the child this night in this year? It'll go further then into things like extracurricular activities. Who takes the child? Who's responsible for paying? Who decides on what activities? How many? And all the details that go with that. Medical care, aside from general medical care, health insurance, but who's going to make decisions? How is that the payments going to be affected on anything that's not covered by insurance? Travel, and a lot of people don't really think about this, but travel within the United States and outside of the United States, that's a typical provision in a parenting plan as well. And then you can add in, every family is unique. There's always special circumstances. You can add in those special circumstances and address it. Obviously, that's oftentimes better done when you can agree and when parties can agree, because then you have control over that. Something that parents always want to know. Okay, if this is my schedule, it's written down, can I deviate from this? Do we have to follow it every day? Well, that's your schedule. That's what you're supposed to follow. But if the parents agree and want to swap a day here and there, want to change their schedule, you're the parents. Go ahead, make that decision and go forward. That parenting plan is there. If there's ever disagreement, if anyone has to file for enforcement, I think you'll hear most judges say they're going to want to look at that document and see what that says.
Yeah, thank you, Jason. And you kind of answered a question that I was thinking, that if originally the parents agree on a parenting plan and at some point they say they want to have the child over for an extra night, could parents communicate that to have that additional overnight stay? So thank you for that.
Absolutely.
What is parental responsibility?
So parental responsibility is a legal term for decision making. Who decides the important major decisions for a child? Just a couple of examples: healthcare, I just mentioned that, education, those types of things where they're really going to impact not necessarily day to day, what is the child going to eat for dinner? That's going to be the parent, whoever has the child that day. But who's the child's doctor? Where's school? What things are going to be involved with school? What's going to happen if there's got to be parent-teacher conferences, things like that? It's the involvement of both parents. It's called shared parental responsibility, which is certainly the most common in Florida.
Okay. And can you talk a little bit about what is time sharing?
Time sharing is, the basic version is the schedule. That is the schedule. Who has the child or children on what days, what evenings. When we look at a parenting plan, we typically look at overnights. It doesn't have to be. We certainly put into parenting plans that children spend daytimes, afternoons, evenings with parents, but the schedule itself typically focuses on overnights. But it very literally is, where is the child at any given time with which parent?
Okay. So there isn't custody or visitation anymore.
Those terms are just not part of the law anymore. They've been absorbed into parenting plans and time sharing. The terms that are commonly known as custody and visitation just really aren't part of Florida law.
Okay. That's really good to know as well. And what is the best interest standard and how is that determined? So
best interest is possibly, it's again another legal term, but may actually be one of the easier ones for everyone to understand. It is, what is the best interest of the child? What's going to affect the child? What is, on a daily basis, what is going to work for them? And judges will look at a variety of factors as to what's in that child's best interest.
Okay. And how does the court determine parental responsibility and time sharing? I know you touched on it a little bit before, but how does the court determine that?
So if you're unable to reach an agreement and you're at trial, then the judge is going to be the final decision maker as to what that parenting plan looks like. So when it comes to parental responsibility, the norm or the most common is shared parental responsibility. But if there is good reason, the judge can award one parent or the other. Majority decision making under certain circumstances. The more rare version is sole parental responsibility, where only one parent makes every decision without having to discuss it. That's got to have some compelling reasons. As far as the time sharing goes, they're going to look at common things that what is the child going through, look at what the parents are doing on a daily basis. You will hear today that there's favor that it be 50-50. Some judges will look at that in different ways, but essentially, where should the children be each night that's going to be beneficial to them and to the family as a whole?
Thank you, Jason, for that. I really appreciate it. That was some really good information. Lisa, are time sharing schedules being affected by COVID-19? And it's actually a two-part question. The second part of the question is, what happens if the court ordered individuals to comply with the parenting plan before COVID-19?
Okay. So co-parenting with an ex-partner under normal circumstances can be extremely difficult. But co-parenting when the transfer of kids can mean exposing the kids to COVID or exposing yourself to COVID is a whole new level of challenging. So yeah, we've gotten many calls about coronavirus and time sharing. The first call that I got was a spring break call, and a lot of times after vacations end, the parent who just had the kids doesn't want to return the kids, and this was one of those. The parties were divorced here in Fort Lauderdale, and mom still lives in Fort Lauderdale. Dad lives out of state, and the kids were at dad's for spring break, which is just about when the coronavirus hit. And so when it was time for the children to be sent back to Florida to mom, he did not want to return the children, and mom wanted some advice about what to do. We had at least one judge. We've had a lot of seminars in Broward County. The judiciary has been just amazing in Broward County. And one of the judges said, I'm not putting kids on planes right now. So that was really like right on point. And so the question is, if the mother files a motion for contempt, she files a motion to enforce the time sharing arrangement, is she going to prevail? And I'm not going to answer that question yet. Instead, I'm going to tell you about a second case that I had.
I'm dying to know the answer.
Okay. The second case that I had was actually our client was just super paranoid. The parties are divorced. The dad continues to work outside of the house, and actually had a couple of these types of cases. And the client felt that the father was being very cavalier about the virus. And a lot of these calls happened right at the beginning when, I mean, all of us were really scared about what was going on. Not to say that we aren't still, but really, really frightened. And so the mother didn't want to send the kids for time sharing because she was fearful that they would be exposed to the virus because the dad was out in public every day. So you asked me a couple questions, and I want to say that the court has been very proactive in keeping the family court moving. Again, they didn't skip a beat in doing these domestic violence hearings and allowing domestic violence victims into the courthouse to file. And all of our hearings have been over the Zoom process. And when we've done really nationwide webinars, we have found that really we were on the forefront. Our county, Broward County, was on the forefront of making sure that the family court did not skip a beat, and you can see why it's so important. So our court was very proactive in addressing what would happen as the pandemic moved forward. So on April 2nd, Judge Jack Tudor, who was our chief judge and just one of the, perhaps the best chief judge I think Broward County has ever had, issued an administrative order 2020-30 regarding parenting during the COVID-19 outbreak. And I'm just going to tell you just a couple things that it said. Regular time sharing should continue as ordered by the court. The idea that the court had was to try to limit emergency filings and hearings. They were kind of trying to set the law and really took away a lot of the questions that people would otherwise have. The order went on to state that it's in the best interest, and Jason talked about best interest. It's in the best interest of both the parties and the children that parents continue to perform duties and responsibilities as co-parents and share the additional responsibilities of parenting right now. And to me, that meant the homeschooling. But there are a lot more time with the kids. And the parties were expected to continue to comply with all orders and court rules. So that's what we've been telling our clients. That's what we've been responding to people who are calling us. You need to comply with the rules and whatever order you're already operating under. It also specifically prohibited each parent from unreasonably restricting access of the children to the other parent. It also said that parties should continue regular time sharing as set forth in the parenting plan while school is still in session. Now that it's summer break, a lot of people, Jason again talked about parenting plans. It includes a lot of questions about how people share time over the summer. And so now people have slipped in, I think as of Wednesday, into their summer plan. So now I'm wondering whether we're going to start getting questions, a lot of calls about, now it's summertime sharing and she's not giving me the kids or he's not giving me the kids. But that's what the administrative order says.
Okay. So I know you explained the situation of a case that you had in the beginning where the parent wanted the children to return back to Florida. What ended up happening with that case?
I have to say that it remains pending.
Okay.
So I can't really address it, but a motion for enforcement, contempt and enforcement was filed.
Okay, thank you. I have another question for you, Lisa, as well. What happens if the parties have an established parenting plan and the other parent tests positive for COVID-19?
Okay, that's really a game changer. That's a substantial change in circumstances. I just want to touch on that one case that probably everybody is familiar with, Dr. Teresa Green. She's an emergency room physician right here at Westside Regional in Plantation. And the judge in that case said that she couldn't see her child anymore. She and her husband had equal time sharing, and all of a sudden he said no, because her ex-husband had petitioned to terminate that. He was afraid that she would expose their child to COVID-19. I'm happy to say that the appellate court paused that decision, and the child's now back to regular time sharing with the mom. But certainly if the parent absolutely tests 18, it's a game changer. That's a substantial change in circumstance. Nobody wants their child to get this virus. Nobody wants to get this virus themselves.
Right.
So it's really important. The Academy of Matrimonial Lawyers put out suggestions, and among those suggestions, they said, be honest with your co-parent about any suspected or confirmed exposure to the virus. Try to agree on what steps each of you will take to prevent the child from exposure. And the court also, Judge Tudor also addressed makeup time. If something happens and somebody gets sick, or somebody has to quarantine themselves for 14 days because they think they were exposed to it, the parties should assume, said the court order, that any party losing time because of the measures taken for COVID-19 will receive makeup time sharing. So that does make your client feel better when you tell them, don't worry, it may seem unfair now, but if he has the child for an extra 30 days, you're going to get that child for an extra 30 days this summer. Okay, so the parties are strongly encouraged to work cooperatively with each other.
Nice. That's really, really good to hear. Because most parents feel like if their time with the other parent was being used, would they get that time back? So that's really good to hear. Thank you, Lisa, for that. That was amazing. Jason, I'm going to come back to you to talk a little bit about child support and alimony. If both parents share parental responsibility or time sharing, does anyone pay child support?
Yes, it's certainly a possibility. It depends on their income. So child support is calculated through a formula. Each party's net income is going to factor in. When you do have equal time sharing, that's called the gross up method of calculating child support. So once you cross 72 overnights, or 20% of the year, you can use that gross up method and it'll change the formula. But if you do have two parents with different incomes, then I would expect child support, yes.
Okay. If child support is not paid, does this give the right to refuse time sharing for either parent?
No, non-payment of child support shouldn't affect time sharing. If you're in a situation where there isn't payment of child support, your remedy would be to go file a motion for contempt and enforcement, like Lisa was just talking about. But certainly I always encourage clients, continue with time sharing.
Okay. I also wanted to ask, is the court moving forward with My Active Family Matters? And if so, how can someone tell?
The court is going forward with family cases. If you need to check on your individual case, the best thing to do is first check the docket, see what's going on. Always reach out to the case manager. Be patient with them calling back because they have been working remotely, both clerks, case managers, judicial assistants, but they have been responding back to people.
Okay. I know that when we talk about child support or alimony, is there a financial, can you explain to everyone what is a financial affidavit?
Sure. So there's two different forms of financial affidavit. There's a short form and a long form. Just starting off, it's a income cutoff of $50,000. If it's under 50, it's the short form, over 50, the long form. But anyone can request the other party provide a long form financial affidavit. The difference between them is the amount of information that goes into it and the detail. The financial affidavit's broken into a couple of sections, starting out with the party's income. And the idea there is to get to what is their net income. So you start with the gross and then take out the deductions. Very similar to a paycheck. If you're looking at your paycheck, you can see what your gross income is and then the deductions that come out to eventually get to your net pay. The next section, you're dealing with expenses, and there are different categories of expenses. Children's expenses being separate from parents, but that's where you would put, for example, rent or mortgage payments, household expenses, food, things of that nature. Automobile expenses is another section. And then the last two sections are assets and liabilities. So assets, very simple. If you have a house, bank accounts, retirement accounts, anything of value is going to be listed in the asset section, and the liabilities on the other side is money that you owe. So if you owe money on a mortgage, you have a car loan or a lease, those types of things are going to be listed in the liabilities section.
Okay. And when
Altogether, you're giving a financial picture.
okay. And is that how you utilizing a financial affidavit, is that how child support is determined?
That's the first step. There's also what's called mandatory disclosure, where you have to provide certain financial documents, for example, pay stubs and bank statements, probably two of the most commonly provided documents, tax returns as well. In theory, all of these should match up. So you should be able to run a comparison and see the numbers. And obviously a tax return in 1 year might differ the next year. But all of the financial numbers together get us to the actual numbers, and the net income is what's used to calculate child support.
Awesome. Okay. Has the calculation to determine what child support is been changed by since COVID-19, or is the calculation has been the same?
Child support guidelines haven't changed. I'll give you an example of something that I've just dealt with in a case. Had a client whose income was temporarily reduced. He was still working, but his income wasn't there. So we worked to reach an agreement where child support temporarily reduced for a period of time and then went back up once his income was restored. Right now, we're trying to be flexible, and with COVID-19, the best thing anyone could do is be flexible where possible. But at the same time, you do have to remember, I mean, children still need support. They still need food and shelter.
Right. I completely agree. And is anyone able to modify or increase spousal support or alimony due to COVID-19?
Yes, you can seek a modification. One of the issues is whether or not the change of income is temporary or permanent. If it's a temporary change, personally, I like the approach that I just mentioned, seeing if it can be worked out. But if you need to seek a temporary modification due to it, you're going to look at that as an emergency and file a motion for an emergency change. As far as a permanent, if somebody loses their job, permanent change of income, then their next step would be to seek a modification.
Thank you, Jason, so much. And I promise this is my last question. Do you have any tips for litigants appearing for hearings on Zoom?
Absolutely. For those of us that have been doing these, every time we do a new Zoom hearing, you learn something else not to do, or you see someone doing something. Every judge is handling it differently. So for example, just about 2 weeks ago, I testified for the first time as a guardian ad litem in a case, and that was a unique experience for me on this end. Couple of things. One, make sure you know what's going on around you. We had a Zoom hearing where one of the participants, not in my hearing, in another hearing, while this particular judge had everyone on hold at the same time, all you heard was his dog barking in the background. It actually made it difficult for everyone else that was trying to have their hearings. The name, we could see I don't know if I'm pointing in the right spot, but you can see our names right here. Pay attention to what that name says. Just out of respect to the court, it would be good if it was your name. It also, I think, helps the judge when they're looking on their screen to see who someone is. Muting yourself when you're not there. Backgrounds, I know I've got my firm background up here right now. If not, what you'd see is just outside into a window. But some folks get on there without paying attention to what's behind them, and it's still it is a courtroom. It's a virtual courtroom, so pay attention to what's on around you. I certainly recommend everyone dress appropriately. Again, same thing. It is a courtroom. Obviously, you're always seeing from here up. So I won't tell you what people are actually wearing. They might be in their pajamas, but at least look respectable from there up. And try and check your sound. That's something important, especially if it's going to be a longer hearing. The sound and video matter. And if you're on a system or your microphone isn't really working too well, it makes it hard. It's going to make that hearing take 3 times as long, because you're going to have to keep repeating yourself. So if that means testing it out the day before, do that. Just set up a Zoom with a friend and check how your system settings are working. Internet connection, always another one. If you're in a spot where you're constantly having it go up and down, if you can go somewhere else to do that hearing, then do that. Because what will happen is you'll be in the middle of the hearing, someone will drop off, the judge has to stop, and if it's a motion calendar, they'll go on to the next hearing, and then you're gonna be stuck waiting until they come back to you. So try to be in a spot where you have that good connection. If you have any issues, I know I said this earlier about appearing with domestic violence cases. If you have an issue where you're not gonna be able to be on the Zoom link, please reach out to the judge's assistant or to the court and let them know the reason. Everyone's being incredibly patient and working with everybody to handle these hearings this way. When I echo what Lisa said, I mean, the judges in Broward have been phenomenal, and they jumped on this very quickly. We really had a minimal amount of downtime without hearings. So absolutely. And if you see something that someone else is doing when you're on Zoom and you realize that that's bothering you a little bit as you're looking at the screen, look in your own background, make sure you're not doing the same thing.
I just wanted to add a couple things. One is that because these hearings are taking a little longer sometimes, you don't know whether your 8:30 hearing is going to start at 8:31 or 10:31. So you need to go to the bathroom before you sit down waiting for that hearing, have a glass of water, etc. I tell my client, plan for the possibility that you're going to be sitting there waiting for 2 hours till you start the hearing. The other thing is tell them if this is a final hearing, they have to show the judge their driver's license. Make sure they have it with them and are prepared to show it to the judge. And the judge must be able to see them. It must be via Zoom if it's a final hearing. You cannot do a final hearing by phone.
I just wanted to add for victims to consider that the email address that they're providing to the court may be confidential or may appear. So to make sure that they do change their name. And these backgrounds are very good for people who want to make sure that if their location is confidential, that it does hide where they are. So victims of domestic violence really do need to consider that as well. And, it may be very stressful to be on one of these Zoom hearings where you have to actually be looking at your abuser the whole time. So many times we tell them to do something as simple as put a Post-it note over that person's face so you don't have to be staring at them. In a courtroom, you could look forward and look at the judge, but when you're on these calls, unfortunately, you would have to just be looking at your abuser the entire time.
Thank you, Jason, Mindy, and Lisa. This has been a great conversation, a much needed conversation given, the times that we're living in right now with dealing with COVID-19 and just being learning how to be virtually savvy, because we don't know how long we're going to be in this situation. So I appreciate all three of you for your time this evening. Mindy, I just wanted to ask, can you tell us about some services available through Coast to Coast Legal Aid for victims of intimate partner violence or senior victims before we end the call?
Sure. So Lisa touched on the services that we provide for victims, and I talked about injunctions for protection, family cases like dissolution of marriage or paternity. We also have a RISE project, which really came about after Amendment 6 passed in Florida, which is our version of Marcy's Law. which is where we can represent victims of intimate partner violence and seniors 60 and older for enforcement of their victims' rights in the criminal case against their abuser. Our partner sister agency, Legal Aid Service of Broward County, serves victims of other crime for their victims' rights enforcement cases, and that's our RISE project. We also help victims of crime holistically. So we represent victims and survivors of intimate partner violence and victims of crime, seniors age 60 and older, holistically. So for example, we can address all of a victim's civil legal needs. Maybe we represent a victim, and I'm going to be a little bit gender biased because most of our clients are females. As victims of domestic violence, it does disproportionately affect women. Although I do have male clients, the majority do identify as female. So we could represent a victim for her injunction for protection and then help her with a dissolution of marriage case to divorce her abuser. Then maybe she needs public benefits. We can help her even apply for public benefits because we know that financial stability can help a victim stay away from their abuser. Maybe they get served an eviction during this time because the abuser's out of the home and they can't afford to pay the rent anymore. We can help them with an eviction. And then when there's a companion criminal case, we're also then going into those cases and representing the victim to enforce her rights in the criminal case. So, you know, we understand that many times it's not just one legal issue that's going to keep a victim from, you know, attaining self-sufficiency. And, you know, at Coast to Coast Legal Aid, we really try to give victims a voice in court, help them exercise their own autonomy and control over their lives and really become survivors.
And if I can just add something, Mindy.
Sure.
I just wanted to talk about our program just for a minute. Coast to Coast Legal Aid of South Florida is a non-for-profit corporation. We are primarily funded by Legal Service Corporation, whose mission is to promote equal access to justice in our nation and to provide high quality civil legal assistance to low income persons. In addition to our family law and domestic violence unit, Coast to Coast Legal Aid has a senior law unit who helps people over the age of 60 and an economic advocacy and community health unit. Those can be applied to as well at 954-736-2400. Thanks.
Thank you, Lisa, for that information. Again, I thank the three of you for your time this evening and educating the community on various topics that we addressed this evening. And so I'm going to turn it over. If anyone has any questions for me, I'm open, but I'm going to turn it over to Miss Alicia.
Thank you, Tabitha. You did a wonderful job as our guest host this evening. So thank you. And thank you to Children's Services Council. Mindy and Lisa, I see you guys virtually a lot these days, but working together is really great. I know how busy you all are. You put a lot of effort into getting this pulled together tonight and then doing it after hours. So thank you both for that. And Jason,
A pleasure.
you as well. You're our pro bono attorney. We know you donated your time this evening and before this to get prepared. So thank you so much for being a part of our virtual clinic series and bringing this information to the community in this very open forum. So we thank you all very much. And for everyone who watched this on Facebook, thank you all for tonight. And be sure to check out our Facebook page for ongoing clinic series and other meetings with community partners at Coast to Coast Legal Aid. Thank you.
Thank you.
Thank you.